Hello and welcome to this webinar conducted by Law Insider. Today we are going to discuss the Supreme Court stand on rape cases and also the settlement in rape cases by throwing light on the recent judgment Mohit Subhash Chavan versus State of Maharashtra, also known for the question, will you marry her, asked by the CJI of India. And for that, we have Ms. Sanya Kishwar with us. Ms. Sanya is an assistant professor at Jindal Global Law School. So, coming to the facts of the case, this alleged incident occurred in year 2014 and 15 when the complainant was only in class 9. She alleged that Chavan, a distant relative, raped her several times from the time she was in class 12 till she was 18 years old. According to a police complaint filed by the girl in 2019, she has allegedly attempted suicide in 2018, after which her mother took her to the police station to file a complaint against Chavan. However, while doing so, Chavan's mother influenced the complainant, the mother and the girl, that if they sign an undertaking, that they should sign an undertaking that when the girl will turn 18, Chavan will marry her, and whatever happened between Chavan and the girl till now was a consensual sexual relationship. But once the girl turned 18, Chavan's mother allegedly refused to agree to their marriage, prompting her to file the complaint against Chavan's on 17 September 2019. 5 days later, Chavan filed an anticipatory bail before the Sessions Court and he was granted the bail for the same. A month later, on 5th February, the girl challenged this order in the Bombay High Court, demanding cancellation of that anticipatory bail. The High Court on 5th February cancelled that anticipatory bail granted to Chavan, who then challenged this petition in front of the Supreme Court. And Supreme Court, while dismissing the petition, gave him the liberty to seek the regular bail and also granted the petitioner protection from the arrest for 4 weeks. So, ma'am, what are your comments on this case? And is this case going to set a wrong precedent?
Thank you so much for the excellent summary of the facts of the case as well as the procedural history of how it developed from the trial court level to the Supreme Court. So yes, as you rightly pointed out, this was a petition regarding an anticipatory bail, and the interesting point to note here regarding the question why or why not it might set a dangerous precedent is regarding the nature of the job of the accused. So here I would like to put forth 2 points quickly that might lead to this decision setting a wrong precedent. If not a wrong precedent, a dangerous one. So first we could say that the question that could be asked is, could the bail be granted to a government employee who is accused of grave offense to save that person from losing his or her job? Now, if this is taken as a precedent here, the question which will still stand will be, if so, to what extent? Now, take an example of offenses such as money laundering. Imagine if such a precedent has been set and the person who has committed this grave offense is a government employee and he has been granted protection from arrest for some days, and in that time he flies away from the country. Now, imagine the situation as to what could be the wrongful implications if this is set as a precedent. Now, we don't know if the Supreme Court wanted us to interpret it in this way, but if it does, then this will be a little problematic for us. Now, the second thing that could be a dangerous precedent over here, if at all this remark or this very thing is taken as a precedent, would be, can the marriage with the so we can ask ourselves a question: does the Supreme Court want us to interpret it in this way, that can a marriage with the victim be a legal remedy for the victim? Now, alternatively, does the Supreme Court want us to assume that it could be a legal option for the accused to escape his conviction? Now, these questions, if we consider this in totality, when we consider it together, So we can ask ourselves this question, that if the Supreme Court wants us to assume this, and if it wants to move ahead in this line, so what's the guarantee? So many questions will occur. So what's the guarantee that the marriage, which is so promised by the accused in order to escape conviction, will be celebrated in reality, right? So then we might even have the question of, would there be someone overlooking the execution of such marriage? And a second thing that also automatically comes into our mind is, what is the guarantee that this victim who has now been married off to her rapist will be safe after marriage? Now we can, and further in my talk, we can also refer to questions like, we do not have any laws safeguarding women against marital rape, acts like marital rape in India specifically. Another question that we might want to ask ourselves, what will be the legal implications of such girl being married off to her accused, and maybe if she wants divorce, etc., etc. How will the court proceed in this regard? Will it also consider the fact that her husband was her rapist in the past, and things like that? Another thing that I would like to note over here, which was a very good step, procedural history as well, when you were presenting the procedural history of the case, was that it did the right thing by condemning the sessions judge. Now, as you also pointed out, that the bail was granted by the sessions judge. However, and we'll discuss this further as well with our talk, we'll see that how the sessions judge wrongfully commented upon the understanding of the girl, that regardless of the fact that she was minor by age, she had the mental capacity enough. And I know this was setting a very, very, very dangerous precedent. And the High Court very rightly condemned the words of the sessions judge and the understanding of the sessions judge. And that, I think, is a very welcome step by the High Court in this regard.
Yes, ma'am. So that brings to my second question, that why Supreme Court granted him 4 weeks protection and provisions of a regular bail, as when Shavan stressed that he is a government servant who faces automatic suspension if charges are framed against him. The apex court said, that's why we have given you this indulgence. We will arrest you after 4 weeks, and then you can apply for a regular bail. So is it something to do with his profession, that the petitioner being a government servant? If the petitioner wasn't a government servant, then the normal charges that are applied to a rapist would have been charged. But as he's a government servant, he's getting this liberty. So is it something to do with the profession?
That's a good question, Khushi. Now, as I also mentioned in my previous answer, so this might be a dangerous precedent because of the nature of the job of the accused. Now, what would have been the consequence if he was not a government servant? He might not have got this protection that he got in this case, but then let's just try to ponder a bit more about the reasons as to why, as you ask here, the reason what might have went across the minds of the judges when they said this. So the plea at the Supreme Court, it was for overturning the order of the High Court that had actually cancelled the anticipatory bail that was granted by the sessions judge. Now, by upholding the High Court's order, at least the precedent of anticipatory bail being granted in such instances has not been set by the Supreme Court. Now, with regard to the regular bail, now they went ahead with the regular bail as an option. We might want to think that the judges, they might have thought, by having a look at the facts of the cases and the arguments, that a clear case is not being made out. So maybe just proceed with the option of a regular bail, and that will also help the accused not lose his job, because after all, he'll go back at the trial court, and then the trial will anyway proceed. And then now the thing over here is that when the accused will even go back to get a regular bail, this fact will stay with him that his anticipatory bail stands cancelled, and this will definitely have a chance, an effect on his chances of getting this regular bail. Now, even if not, there is still a chance of appeal against his bail being granted in a regular fashion. If it and at all, if it reaches Supreme Court or maybe even High Court, then just like it did now, we might get more insight on what was going across the minds of the judges. Then maybe, right, because they were very unclear as to why they gave him a this protection of being arrested. Then another point to be noted here is that the Supreme Court did remark of his job before committing the crime, and now he should be prepared for facing the consequences. However, even after saying this, they did grant him the protection, and this was a bit confusing. So even I don't know whether they wanted us to believe that it should be a precedent for matters of similar instances or not. But yes, let's just hope that this gets clearer. Maybe it might get clear if the Supreme Court is faced with another such case, and if they do not if they do not grant such protection or chance for a regular bail, etc., maybe then we might come to a conclusion that in this instant case, this was only something that the Supreme Court did by keeping in fact the merits of the case on a case-to-case basis, or maybe having having a look upon the facts of the case, a rough look at the facts of the case, right? So this might be a reason that something that comes across my mind when I want to put pressure on my mind and think why the judges actually did so. But then something that the judges did stays with them, and we really need more insight from them in the coming future as to whether they want it as a precedent or not, and what would be the implications of this move by the Supreme Court in this case.
So, ma'am, that brings to my next question. That is, whether when this matter went to the Sessions Court, the court granted the petitioner bail by considering one of the factor that the girl may be minor physically, but she was a major mentally, because there was a use of contraceptives and she was aware of it. So, and the High Court denied, while denying this bail, regarded this judgment given by the Sessions Court as atrocious in nature. So, ma'am, what are your views on it?
So, of course, yes, the High Court did the right thing, and let's take into consideration how wrong the Sessions judge was. Now, the girl was minor, and as per the POCSO Act as well, the consent is immaterial, and that was rightly pointed out by the High Court as well. Keeping that apart, even keeping that apart, now any girl, especially now when even from a small younger age, any girl, especially now, younger children, even they have an idea of the sexual acts that are being committed against them or committed with them. That's exactly why we have this protection, this statute of POCSO, in which the children can very well explain as to what made them uncomfortable and why are they claiming that something wrong physically, but she was so major mentally that she had an idea of what was going on. Of course, any girl would know what's going on with her when she's being sexually abused, and just because she said that he used contraceptives, this doesn't have anything to do with her consent over here, right? We do have many cases of rape where the accused uses contraceptives. So that doesn't, it's a very irrational remark by the Sessions judge. Now, also, if that is what the sessions judge wanted to be a rationale that he wanted to apply. Now, why would he just want it to be applied to victims only? Now, the question that remains, would the sessions judge be in favor of applying the exact same rationale that the person was minor physically by the virtue of his or her age, but he or she was a major mentally because of the act that he committed? Now, take an example. Like, would the sessions judge want this to be taken as a rationale when he might be assessing a question where the accused is a minor or a juvenile? Now, a few days back, I came across this news of a 14-year-old boy raping his 4-year-old relative. Now, if the sessions judge had to comment upon this, he might have commented in the same fashion that this boy who committed this atrocious crime, he was minor by age, but he was major by by his mental understanding. Right. So would that mean that there should be a reform, a much needed reform in the juvenile laws of India? So why just apply this rationale to the victim? Why not apply it across the board and also include this rationale for minors who are committing such atrocious crimes, such grievous offenses? For example, let's also take into consideration the implications of what the sessions just said. Now, we have this concept of dolly incapax, where a person, say it's below an age of 7 years, maybe, is considered to be incapable of committing a crime. Now, imagine if that child does commit a crime. Now, would he or she be considered to be a child physically but an adult by his rationale and thinking? Right. So these are the questions that come across as a practical implication of what the Sessions Court held, and it was a very right attempt by the High Court, and a very right a remark by the High Court that what the Sessions Court said was atrocious in nature, solely based upon it was kind of biased against the victim, someone who is actually struggling with the repercussions that she has been facing because of the crime that has been committed against her. So yes, the whole remark of the Sessions judge was rightly pointed out by the High Court, rightly condemned by the High Court to be something very atrocious, something very irrational. So yes, that's my views regarding what the Sessions judge said.
Okay. So, ma'am, the next question which I wanted to ask, ma'am, in the judgment Shimbu versus the state of Haryana, it was held that religion, race, caste, economic or social status of the accused or victim, or the long pendency of the criminal trial or offer of the rapist to marry the victim, or the victim is married and settled in life, cannot be considered as a special factor reducing this sentence prescribed by the statute. The power under the proviso should not be used indiscriminately in a routine, casual, and a cavalier manner for the reason that an exception clause requires strict interpretation. Ma'am, that judgment was of High Court and doesn't have any binding value on Supreme Court, ma'am. But don't you think that these legal facts which were held in that High Court judgment should be applicable in this case also? Like, will marrying the victim removes all the charges applied on the accused?
So I would start with saying, I wouldn't think that this remark of the High Court in the case of Shimbu would necessarily be applied to this case, not just because of the reason that it was a High Court's judgment and it is not binding on the Supreme Court, but also because the question before the Supreme Court in the case that we are discussing today was not regarding the conviction or the acquittal. It was actually regarding the anticipatory bail. So I don't think that this would be the case, but however, I do see your concern over here. And that concern stems from the remark that CJI gave when he asked if he would marry the victim or not. Now, the question that remains with us is, why did he ask this? Now, one reason that that might be because the high courts and the district courts, we have seen recent examples in 2020 as well, some decisions by the Orissa High Court, and I guess maybe even subject to correction, I guess even Kerala High Court, but again subject to correction. Some high courts and district courts, they have granted regular bail to accused to marry the victim, maybe sometimes 2 months, sometimes 2 weeks regular bail, or 1 week regular bail to marry the victim, and then the charges get disposed of. Now, however, this is a very dangerous precedent, and now we are left with the question that, did the Supreme Court ask this question to walk on the same pattern? Did the Chief Justice want to include this practice at the Supreme Court level as well? And the problem that arose here after the question is, that the accused, he said he got a chance, actually, when he was asked the question, he got a chance to reply, and he used it to his favor, and he said that he actually wanted to marry her, but then she refused. She refused because we all know she refused. Even if she refused, we don't know whether she did or not. But even if she did, she was a minor. She couldn't have been legally married. But nevertheless, he got a chance to say this, and he said in his response that he very well wanted to marry her, but then she refused, and that's why now he's married to someone else. Now, this could be used by the accused to show that his promise to marry her, and we have the facts of the case which mention that there was a stamp paper in which there was sign of both the parties as well as their mothers. Now, he might use this statement that he very well recorded at the Supreme Court level as well towards his favor, and he might want to say that his promise to marry her was not false, and he had an intention to marry her, etc., etc. But then another point that comes here is the issue of consent, whether that consent was taken falsely or taken through whether the consent was correctly taken from the girl. This question doesn't even have a role to play over here, because when the act was committed with the girl, she was a minor. So we might want to think again why this question was asked, right? So it doesn't fit in well in this case. It might have fit well if the victim was an adult. Then the question of whether or not the consent was taken falsely, with a false promise to marry her, these questions might have been taken into consideration, but only if the victim was an adult when the act was committed against her. Now, this doesn't fit very well with the instant facts of the case. Now, another point here is that the sessions judge said, and we discussed in our previous question as well, that she was a minor by age but adult enough by understanding, as she stated, as that contraceptives were used sometimes. So even though the issue of consent is immaterial, as she was a minor at the time of the act, if we take this argument of the Sessions Court, let's just for a second assume that somehow it is proved that the girl, maybe somehow, just somehow, in our wildest imagination, that the girl was actually not a minor when the act was committed, and now the intention of marriage, this whole question of a false promise, intention of marriage, these things might come up, right? Now let's just imagine for a second. But this will only stay with us in the wildest of our imaginations, because if the girl is claiming that she was minor, she would have enough proofs to show that she was minor when the act was committed, right? So now again, even if we take this argument just for argument's sake, even if we go with the line of what the Sessions judge said, this argument will not move ahead when she would show enough evidences to prove that she was actually a minor when the act was committed, and now it will fall under the purview of the POCSO Act, and the whole question of consent will be rendered totally immaterial. So again, even by going through these two ways, either way, we are left with this question as to why even such question was asked at the first place. Will you marry her? How does this even fit in the instant case? Why was this useful? Let's just imagine if the accused was not married. Now, if he came back with an answer, yes, of course, I will marry her, what would have been the next step of the CGI? That was something that was left unanswered, because just because the accused said that, no, I'm married to someone else and I cannot. What if there is some other accused and he's not married, and maybe in some other case, and he says, yes, of course I will marry her? What would the CGI do then? Will he say that will he direct the trial court to remove all the charges and immediately grant him general bail for celebrating the marriage? So yes, it does make us ponder over this question as to why after all. Yeah, so that's some of my views regarding this remark.
Ma'am, as you mentioned that the consent of the victim is also necessary, like while giving these kind of judgments. So ma'am, that brings to my next question. The court asked the petitioner that will he marry her? But what about the women's opinion? Will she marry her rapist? What if the rapist continue doing that, what he was doing that before? So isn't it showing the patriarchy of the judges? And also please explain us more about marital rape.
Thank you so much for the question, Khushi. So I'll take your first question first. What about the consent of the victim in this case? So legally, yes, she can marry her rapist if this is something that she wants through her free will. Now, she has a right of choosing her partner, but morally, rationally, I don't think any woman would want to marry her rapist. Now, you see, khap panchayats do this often, and we very well condemn the khap panchayats. We have articles condemning these decisions of khap panchayats, right? So why would we allow this to be something that's a practice being taken up by the courts? Right, when it's something that we despise when khap panchayats do it, we should equally despise this when the courts do it, right? So yes, surely it shows a patriarchal mindset, but I wouldn't say the patriarchal mindset of the judges, because we are not very well aware of the reason why they asked this question. But just commenting upon the patriarchal mindset at large, this idea of biasness as to what factors bias us when we have a remark regarding some incident like these biasness stem from our being from the factors like the place where we have grown up, what we have seen around us, etc., etc. And even while growing up, every one of us have seen that this idea of honor of a family, reputation of a family, this is very tightly tied with the virginity of a woman, with the reputation of a woman, with her honor, right? Now, if a woman is raped, she is considered to be impure, rejected, as if she's some object, and the only way that could redress it, that could undo this wrong done to her, is just marry her off. And now the question that we first listen, who will after a girl is raped, the first question is, now who will marry you? Now you are impure, who will marry you? So when you're a rejected, as if she's a rejected object, and now no one is going to marry her, so let's just marry her off to her rapist, because that is one he is the person who made her impure, so just let us marry her off. But as you very rightly pointed out, Khushi, that what's the guarantee that she will not have to go through the same turmoil again and again? Now, imagine a girl being married off to her rapist. She would have to live the same thing again and again. I mean, rape, sexual harassment, it's a trauma, and she would have to go through the same trauma again and again when she'll be having regular sexual intercourse with her now husband after the said act of marriage. And the touch itself would not make her comfortable, because all the trauma will come back. Now the society, of course, the biasness that the society has, it will of course say that, why are you even uncomfortable? Now he has married you. But the trauma still stays in the mind of the survivor. Now the second thing that also concerns us over here is, we do not have any laws safeguarding women against the act of marital rape. Now we have the Supreme Court's remark, where they said that in India we don't need laws against marital rape. We will actually be intruding into the private sphere of this sacramental and sacred institution of marriage, and that's not something that we want to do. Now by saying this, we do see that India at large has accepted this fact that even if a wife is sexually assaulted by husband, and when I use the word sexual assault, I mean that her consent is not taken before the sexual intercourse, that very well makes it a rape. But India at large has accepted this fact that those acts would not be considered as rape, just because of the nature of the relation that these two people share. That is the nature of marriage, that is the relation of marriage. Now this brings us back to the question as to, do we consider this marriage as a stamp for rape? If so, now this also shows us this might help us to get more, further insight as to why some high courts and some district courts are allowing the accused of such offenses to go ahead and marry the victim. Right. Now another practical implication that might arise from here is not just marital rape would be an issue, but other issues. What will be the guarantee, as I also stated earlier, that such marriage that has been promised in the court by the accused to escape the conviction will be realized in reality, right? Would we have some execution officers, etc.? Now the second question that also stands here is, what will be the guarantee that after the marriage, let's assume that the marriage is done, after the marriage, this man will treat her nicely. Not just this man, his family will treat her nicely. Now we have these great laws in India safeguarding women against domestic violence, etc., etc. But we know how badly these how less these have been helpful in safeguarding women from acts such as domestic violence, dowry, etc., etc. A lot of things will come into question. Now another question that also comes into my mind is, what if this man marries her, okay, just to escape the conviction? Maybe even if she agrees, okay, yes, let's just forget everything and just marry me. Maybe if the girl has her consent, let's just assume this classic case, and then he marries her, and she's looking forward to a new life, trying to forget everything that happened to her in the past, and then this man, he just abandons her. Now what will be the legal recourse that this girl will be having? Maybe she'll go ahead and file divorce on the ground of desertion, but then will the society again accept her back? They'll again say, oh, you know what, now your rapist, even he left you, and who will marry you? And then things like these, and again this whole vicious cycle of honor of the family has been destroyed, and oh my god, this girl is doomed, things like that. Now some other points that I would like to mention over here, and that will show us that this is not just a thing that we struggle with in India, but this is a thing that women struggle at large across the borders. We have the case of Syria, where the act of child marriage is actually something which is advocated by the people there, and they say that yes, of course, we wouldn't want our girls to be raped. Rather, why not just marry them off at an early age to safeguard their virginity, and then in that by doing that, we'll also safeguard the honor of our family. The same thing you might see the same thing in Africa. Female genital mutilation is a practice that is well advocated by the seniors of the family, and they say, why we are doing this? We are doing this to safeguard our girls from being involved in sexual activity before marriage, and from even if someone wants to rape them, they'll not be able to intrude into her private parts, and that's by doing that we're actually safeguarding the honor of our family, of our society at large. So what do we see here? Even if the act these acts are being advocated even across the globe, now we see that the bias is against the women. Did anyone, even in Syria, maybe let's just take an example, did anyone ask the men to be married off at an early age to safeguard their virginity? No, of course not. Now, in Africa or places where female genital mutilation is an accepted tradition, this whole obsession is with keeping the virginity of the women intact, and even if the act of rape is being committed, so her virginity could not be destroyed by her genital mutilation being already done. Now, did the people actually ask their boys to not rape women? Right. By asking these questions of why not just marry a rapist and things will be settled, you're actually giving an upper hand to the rapist actually. So you are subjugating the woman then, even if she doesn't have her free will to marry. Then these societal factors, these traditional factors, this pressure of the society, the pressure of a family, the pressure of a senior, elders, and the relatives and society at large, will trick her into accepting this act of marrying her rapist. So yes, totally, it does show the patriarchal biasness in India. And yes, that's a very sorry state of affairs that we have in our country. But yeah, that's exactly what we have to think about combating in the coming future.
Yes, ma'am. So, ma'am, that brings to my last question for this session. What are your views on the future of rape culture in India after knowing about the recent judgments? For example, in Satish Regre versus State of Maharashtra, the court held that the act of pressing of breast of a child aged 12 years in the absence of any specific details as to whether the top was removed or whether he inserted his hand inside the top and pressed her breast would not fall in the definition of sexual assault. So, ma'am, what are your views on it?
So I was very, very, very upset at that decision, and this is the thing in India. All laws that we have are subject to interpretation, but does this mean that any interpretation should be accepted, right? Just as the case that you mentioned about Satish versus State of Maharashtra. You see, not just that one case, but 2 or 3 more cases were decided in the same fashion by the Bombay High Court, and we are left with this question that in India we do accept judge-made law, we do accept this act of interpretation by judges, but there needs to be some check and balance over the extent of interpretation, and to what extent they could interpret, in what ways they could interpret. Now, as you asked this question regarding my views on rape culture and the future of this in India, I'm not very positive in this regard. Bluntly speaking, I really do not think that this is something that's going to be sorted out maybe in the near future. And by near future, what I have in mind, I don't think that this is going to be sorted maybe even in 50 or 100 years. The only reason I feel so pessimistic about this whole state of affairs in India is because of many factors. Now we have this case of we have this Nirbhya's case, probably the most gruesome case in India that was condemned across the international borders as well, and that led to huge amendments in the laws in India. What was the end of this case? Now, first, the justice was delayed, the execution was delayed. Even though it was delayed, now that was delayed because of the legal frameworks that we have in India. Now we have this framework of reference, review, appeal, mercy petition. But let's just take a moment and think, what was the end of this case? The justice was delayed, the execution was delayed. Another question that we have to ask ourselves, was there any deterrent effect? Was there any effect of deterrence? Did the mindset of the accused change? Now we have this interview by someone who went to interview one of the convicts in Nirbhaya case when he was awaiting his execution, and even behind the bars, the statement that he said clearly shows that the mindset of the accused did not change even after the whole hullabaloo being prevalent in India. He said, "Tali ek haath se nahi bajti." This shows that where the problem lies. The problem lies in the mindset of not just the accused, but society at large. Why society at large? Now let's look at what was the reaction of the mother and wife of one of the convicts when his execution was confirmed. Now the wife said that अगर इन्हें छोड़ देते जिंदा तो कम से कम मेरा बेटा इन्हें देख तो लेता, जानता कि मेरे पापा कौन है. Now two things over here. How is that woman? Now she's a woman as well. Now how is she okay with the fact that a person who is being executed for a gruesome crime of raping another woman should be given access to her child, who is again a man? Now this is the factor over here, and the second factor over here is, why is she even happy with the fact that she's she's his wife? Now she said that mera suhag to zinda rehta. Now why would a woman even consider a person who has been accused and convicted, not just accused but also convicted of this gruesome crime of raping another woman, right? So now also look at what the mother had to say. हमारा तो एक जवान बेटा चला जाएगा ना. So this whole set, and these are women who are commenting, right? So they are not, they just want to forget this thing, what their beta did, raped a woman. They just want to concentrate on this fact that beta to zinda rehta, pati to zinda rehte, iske papa to zinda rehte. This is where the problem lies. Now, if I say that I'm not positive about this rape culture being diminished in the coming future just because of the mindset of the men, I would be wrong over here. Women in India and across the globe are women's worst enemies. And you see, not just this example, but let's just take an example of domestic violence even. The first person from whom you will hear, beta adjust kar lete. Why didn't you adjust? Why did you just quarrel with your husband? If he just hit you once, you should have just stayed there, mom, and adjusted it. At least you wouldn't have been divorced, etc., etc. The first person to say this will be the mother of the victim. Now this is very sad state of affairs. Now even highly educated women, we have this case of Aisha's suicide. She was highly educated. She was an MA final year student in economics, and she was working. She was very well employed in ICICI mutual funds. Now the pressure of the relatives, the remarks of the society, and this whole idea of ab beti kya karegi. not just regarding rape, but other things as well, right? So this obsession with ab kya hoga, as if a woman needs a man to survive. This obsession with agar tumhari zindagi mein ek aadmi nahi hai, so how are you even surviving? This whole taboo against divorce, this whole taboo against single mother. These things, this mentality doesn't make me feel positive that not just rape culture, but atrocities against women at large. I don't think that that's a thing that we are going to get rid of. I don't know how much time it will take. And I do have a side remark over here regarding, when we are talking about crimes against women, we should not be focusing just on the accused being the perpetrator actually being male, but we should also understand that there are other crimes that are also on the rise over here. I came across a recent news that there was a homosexual activist who has been charged, who has been accused by another woman, and she was a woman. The accused over here is a woman, and she was charged of drugging and sexually violating, violating the private parts of another woman. Now these things are on the rise as well, with the society being more progressive, and we also have the decriminalization of the act of homosexuality. Now the problems which stays here is we need urgent laws to safeguard people in a homosexual relationship. So we can't just keep our mind focused on a man sexually harassing a woman, but we need to keep our minds focused on these things as well. A woman harassing a woman, a man harassing a man. Another thing which might come out as very progressive when I speak of it, but I do want to put it out here for the audience at large, is we should also be open to this idea of a woman harassing a man. Now, when I say this, it might not make sense, because obviously the number of cases of men harassing women are way, way, way large, and women are at all times vulnerable. And you might say that it doesn't make sense, but it does. It does. Now, see how non-neutral the laws in India are. We can see that we have protection of women against domestic violence. Now we have the act of protecting women against sexual harassment at workplace. Now, what about the situations when the senior is a woman and she asks for sexual favors from her employee? And in that case, the consent, again, is not a free consent, right? So technically, if the tables turn around, and if the victim is not a man and the victim is a woman, then we would label this as a sexual harassment. We would label this as a molestation. But why are we not open to this idea of labeling it as a sexual harassment if it's otherwise, if the victim is a man, right? These things do happen. We do not speak up against this, because who will believe the man then? And secondly, the woman can go out over there and say that, it's not me, it's he who raped me. And the whole thing just gets too messy. And things like these are on the rise, and we need to be more we need to accept a broader stance and a broader perspective of looking at these things. But yes, again, as a closing remark, if we talk about the rights of women, again, just as a closing remark, I would like to say the change will only come when we follow what we preach. Now you might see me and many other women asking other women to speak up, asking other women to not be subjugated, not accept subjugation at the hands of men or maybe other women, right? But then when it comes to following, we fail to follow what we preach. So maybe that's something we could use as a way ahead, and we might start here. We might start to follow what we preach, and secondly, we might also want to improve the questions that we ask our girls and our boys. Maybe we might do away with asking this question to our girls, why are you going outside, be safe, and we might want to replace it by asking our boys as well to not commit any crime when he is going outside at night, right? When he's going outside, he should keep in mind that he's not being allowed to go outside to rape other women, but he is being allowed to go outside to do his work, just like women should be allowed to go outside to do her work. And we should now that the society that we live now, we are in a state where we have started to kind of accept this fact that if men are not going to stop from harassing us, we should keep ourselves safe. We have started to stop our girls from going outside late at night, things like that. We have been telling them to cover more. क्या ही कर सकते हो, वो अपनी आंखें नहीं नीची कर सकता, तो तुम ही बेटा 2 कपड़े 4 कपड़े ज्यादा पहन लो. So this is a very sorry state of affairs, sad state of affairs that we are facing, and we will start to realize, we will start to feel that the change has finally come when this thing will stop, when we as women will actually feel safe while going outside. We as women will feel free to wear the clothes that we want. We want, not bothering ourselves about wo dekh raha hai, things like that, right? So yeah, that's something that I would want to put out there for audiences at large, and that the change comes not just from within, but the change comes when we start noticing the change, and noticing the change not just at large, but even 1 or 2 people who get reformed is a big change when keeping in consideration the state of affairs that we are living in today. So yes, that's what I would want to put forth as my views and what I think about the future of this whole rape culture, as well as subjugation of the rights of women.
Thank you so much, ma'am. Like as you rightly said that like it's time for men to change their thinking and their mothers to change their thinking that women is always not wrong. They should definitely educate their children, their boys, that they should respect women. So once again, thank you, ma'am, for taking out time from your busy schedule, and like it will really help to whoever listen to this webinar. Thank you, ma'am.
Thank you so much.